Development Council, the Real Estate Kings, and Motilal Oswal Private Wealth Management. I would like to thank you all for attending today's educative webinar on will versus trust and estate planning. I would also like the opportunity to thank our supporting partners, South Metro City Association of Realtors, Real Estate Agents Association of Kandivali, Thane Real Estate Association, and Association of Real Estate Agents group for this webinar. We are privileged to have amongst us our chief guest, Dr. Niranjan Hirandani, President NAREDCO National and co-founder Hirandani Group and founder chairman of Hirandani Communities. He's a doctorate in management with a bachelor's degree in commerce from Mumbai University and FCA from the Institute of Chartered Accountants of India. He's often referred to as the Tsar of real estate in India for his vision, perfectionist attitude, and an untiring zest for excellence. His immense knowledge in real estate and contribution to the sector has earned him the reputed position of the National President of NAREDCO that operates under the Ministry of Housing and Urban Affairs, Government of India. Moreover, he also represents the apex body of ASSOCHAM as its president. We also welcome our guest of honor, Shri Rajan Bandilkar ji, Vice Chairman NAREDCO Maharashtra and Director of Ronak Group. His contribution towards the upliftment of our industry and NAREDCO has been significant. Mr. Bandilkar dwells his belief in the fact that hard work and passion are two strong pillars that paves a person's way to growth and success. Mr. Bandilkar is also a conciliator and a core committee member of the Maharera Conciliation Forum. Thank you so much, sir, for taking out time and joining us today. The broad topics which will be covered in today's webinar include will versus trust, gift deeds, nominations, family arrangement, etc. I would now like to call upon and invite Mr. Ashok Monani, founder Ekta Housing Private Limited. For the past 33 years, he has been the driving force behind the metamorphosis of his organization as Ekta World, a multi-city construction group. Through Ekta World, he has endeavored to give our city the structures that we can be proud of. He's the president of NAREDCO West and the president of Khar Gymkhana, and is also the founder, member, and trustee of Shraddha Rehabilitation Center. Ashok sir, over to you, please. Thank you.
Thank you, Pratik, for the lovely words. Good evening, friends. Chief guest of this wonderful evening, Dr. Niranjan Hirandani, my mentor, my president of NAREDCO National, my dear friend Rajan, vice president NAREDCO National, our keynote speaker, Neha Patak, my friends, Ajay, Ajit, Pratik, Ashok, everybody who's there from Trek, from SMART, from Thana Estate Association, from Kandivali, from Area Group. A very warm welcome and good evening to all of you. As Pratik just told you that we have joined together for this webinar today to understand more about trust and will planning. Let me tell you before, of course, we hand over the baton to Neha. Let me tell you that NAREDCO has been formed in 1998, and under the leadership of Niranjan sir and Rajan sir, we have over 5,500 members. We've put in our blood and sweat for the industry, and we've done everything that is possible to ensure that the market gets revived. The first thing that we did, Niranjan sir, was, and what we all did together was about reducing the stamp duty to half. We had promised Aditya ji at that time that if you reduce it to half, we will contribute the remaining half. And I'm telling you, my channel partner brothers, that we all did that. The developers, over 1,000 projects from NAREDCO passed on the benefit. We also worked on the UDCPR. Okay, now it has become the level playing field for all developers, for all channel partners, for all the stakeholders. The other thing which NAREDCO was successful in doing was reducing the premiums to half up to 31st of December. This benefit ultimately goes to the consumer. Everything that we've worked on is finally goes to the benefit of the consumer, and you channel partners, you brothers are all concerned about our consumers. The interest rates on housing loans has been the lowest in history. It has gone down to 6.6%, if I'm right, Niranjan sir. Now, friends, we have Miss Neha Pathak, who is highly experienced and an expert in the domain of trust and estate planning. And with her experience of more than 15 years, she's going to share the experience with us. And today she is going to enlighten us what are the benefits of a trust, of a will, of a gift deed, of I think somebody needs to put off the has to be on mute. If the admin can do that, I'll be grateful. So the benefits of a family arrangement vis-a-vis a trust, vis-a-vis a will, everything she's going to educate us. She's a law graduate from KC College and has done several webinars on wills and trust. I have with me my co-moderator Ajit. Ajit is, has been a part of Trek and is the president of SMART. SMART has also collaborated with Trek and with NAREDCO for this wonderful webinar. Without much ado, I will now call upon my Vice President National and Chairman of NAREDCO, Rajan, to give his views and to share his wisdom. We also welcome before that Kishore Bhatija, who's Vice President NAREDCO Maharashtra, who's with us. Welcome, Kishore. Now I hand over the mic to Rajan.
थैंक यू अशोक. आप वो बोलते हैं ना कि शेरवानी सूट में बहुत अच्छे लग रहे हो सर. Very good afternoon to all of you and our NAREDCO's boss and who's who, Niranjan Hiranandani sir. Very good afternoon to you. Kishore Bhatija sir, who is Vice President. Neha Pathak madam, very good afternoon to you. Ajit Rao, Ajay Kapoor, Ashok Narang sir, and who's who from the channel partner industry of real estate. A warm welcome to each and everyone. Friends, everyone is blaming COVID because COVID के वजह से हमारे को तकलीफ हो गई, धंधा बंद हो गया, प्रॉब्लम हो गया. But I think it other way around. I see other side of the coin. COVID has really been a blessing for real estate industry. Majority of the people will tell you what I'm talking, but believe me, I think in last 6 months, if you see the last 2 quarters of year 2021, everyone has done more business than what they have done in 2019-20 in that 6 months. The second is what happened because of COVID, stay at home, be safe at home. So wherever you see, home has become a so much popular word in time of COVID. So home has become a key word for each and everyone, every individual, every family, more than every family, a lady of the house. For her, it has become a very, very important aspect. This I keep on telling in my each and every conversation, that if you ask a lady of the house whether you want a foreign tour or a good car or some jewelry or anything, she says, I don't want anything of this. I want a shelter above my head. That is very, very important. And that's what we have all seen in past 6 months. Of course, the way Ashok Monani says, thanks to Maharashtra government, because NAREDCO played a very, very key role. Niranjan Hiranandani has led that movement. And as Monani sir told, more than 1,000 developers under 1,000 projects have given zero stamp duty, because in the month of April, when COVID was on its peak, we had called Aditya on our webinar, and we all members of NAREDCO had assured them, whatever stamp duty amount you reduce, we will reduce equal amount and we will give it to the buyer. So our appeal was that you make 50%, we will bear another 50% and it will become zero stamp duty. And NAREDCO has also, you must have seen in majority of the newspaper, we ran a campaign also for that. So, and we all have seen that result. And by this, not only developer industry has been benefited, even channel partners have benefited, banks have benefited, majority of the banks whose loans were going to become bad, they have come into normal or they are repaid. So it was a win-win situation for all three of us. Second important aspect, what your topic is trust. See, a very important aspect in real estate is trust. But I believe the trust is put in by channel partner between developer and the consumer. Because channel partner, I feel channel partner works like a glue between developer and consumer. Because the channel partner, if he has trust and faith in the developer, of course, he is going to talk positive about the developer and he's going to say that, and that will create more confidence in the home buyer. And that will help us in converting that deal. So, without taking much time, I would like to thank Trek and even Ashok Manani sir also for inviting us here. And over to you, Ashok Manani sir. Thank you very much.
Yeah, thank you, Rajan, for enlightening the forum. I'll be failing my duty if I do not recognize, the efforts taken by Ashok Narang. He was the sutradhar and, a conduit in bringing us together for this event. Thank you, Ashok. We also recognize the presence of Prashant Sharma, our secretary of NAREDCO. Then we have Pratik, Rajesh Doshi is our treasurer. We have Vishal Thakkar, and we also have Jay, our president of the next gen. We have Rishabh with us, and I'm now looking forward and requesting our president Niranjan sir to please share your views and your wisdom with the crowd. I mean, we have crossed 300 participants already, sir, and the count is going on.
So my heartiest congratulations to all of you and all of us. Ashok, congratulations. Wonderful job that you are always doing in the leadership that you have taken with NAREDCO Maharashtra. Rajan, of course, has been my right hand and left hand. So thank you, Rajan, for everything that you do. Great job, Ajit Rao. Fantastic. Ashok Narang, Ajay Kapoor, all superb. Neha, wonderful to have you over here from KC College. That's our college. So I'm happy to see you over here, Pathak. And we all have to die someday. So I think the will and trust preparation looks quite appropriate to learn about. And I want to sit and hear what I have to do, immediately after the session is over. I want to do it, and I guess I must recommend everybody over here to follow your advice to do it. My congratulations to each and every one over here who have played a great part in terms of the real estate operations, and really it has been fantastic. I think the fact that all of us have worked together in terms of doing it, and I'd love to mention, rightly so, all the other people who are here today. I think we can continue to do a lot of things, but when we continue to provide shelter to people and create a commitment that we are doing now, which is different than what we used to do before in terms of improved commitment. Also, all the members in terms of channel partners of different regions, the suburbs, the city, Thane and New Bombay, and all these people who are here today, I think it's fantastic to be here. So our objective should be one. We have to take care of the health and hygiene of our people. There is no way that we can get away from it. And we have realized to our own feardom that we can lose a lot of people if we don't take care of our people, young, old, all the people and all. So I must tell you and share with you that there are horrible stories that we hear about things happening, but there are good stories of people who are safe. So we all together shall do the best that we can. And congratulations for all the programs that you are arranging. I'm happy to be here with you. And we together, NAREDCO, other organizations together, we shall and we can. So I wish you all the very best and looking forward to hear from Neha Pathak in what she has to share with us. Thank you.
Thank you, sir. And let me tell you one thing. At such a short notice, last evening I called Niranjan sir, and immediately he accepted our invitation. And he not only accepted, but he also said that I would like to stay for the entire event, for the entire program. So this is the humbleness and this is the greatness of Niranjan sir. I also recognize Maulik's presence of Maulik, Sanjeev, Ajay, and Avinash. Now I request Neha to please take over, and we all are waiting to hear from you, Neha.
Thank you very much, sir. I'll take a minute over here to thank all of you, especially NAREDCO, Trek, SMART, and all the other real estate associations that have been a part to organize this event and having me over here as a speaker. And without further ado, what I'm going to do is I'm going to share my screen with you and take everybody through a presentation. It's a quick presentation. Is my screen visible?
Yes,
Yes,
yes.
it is.
All right.
Yes,
Thank you. All right. So this is So this is what I think Mr. Hiranandani just said, that we need to get organized at some point of time. We might not be around for it. And based on this saying, what we have done is we have made this presentation and divided into 3 parts. That what is estate planning, how do we do it, why do we do it, and we have got a case study and summary of this. So estate planning, this is a process. Basically, it's a very simple process of transferring one's estate during his lifetime or after his lifetime. What can be a part of the estate? It can be his property, it can be personal assets, it can be business assets, it can be anything that is held in a person's name. It does not include that any asset I purchased for my family. It is not in my name. I just have to plan something that is in my name. So how do I go about it? I go about it by different instruments of estate planning. So there are gifts of family arrangement, there are nominations, there are wills, there are private trusts. So let me start by what actually gift is. Gift is, as you all must be aware, it's anything that you hold in your name, you can gift it to any other person during your life, and this gift has to be irrevocable. With what it means कि मैंने एक बार दे दिया, I cannot take it back. That is a gift. It is a kind of planning. Like a lot of times people give their assets, father will give the asset to the son. But then, at the end of the day, father is relinquishing himself from that asset. What if he needs that asset? Then in that case, it can become a little difficult. And it is not exactly the right or the best form of estate planning. Though I would say gift is a part of tax planning. It is more like a tax planning where you say that whoever is the member who's earning the least probably transfer a property or transfer certain assets in that person's name. Similarly, there are family arrangements or family settlement deeds. Now, these are something that can be oral or written. So family or family members, they get together during their lifetime and they decide that who gets what, to remove any kind of present or future disputes that may have arisen or may arise. To remove that kind of confusion, people come to terms with each other and create something called a family arrangement. If you want the tax exemption, so if you transfer an asset in someone's name, be it business assets, shares, or real estate, and you want the that there should not be any capital gains implication on that, then in this case, one has to prove that this family arrangement is done once in a lifetime and cannot be repeated again. There are enough and more tax and legal case laws on the same. A registration of this particular kind of arrangement is required only if it is reduced in writing, 1. 2 is if it is creating any kind of title. So if you are transferring any real estate, then in that case, one would require this family arrangement to be registered. Then we come to, I missed out on one, which is nomination. What is nomination? We all are aware of nomination. Nomination is there in real estate. Nomination is there in insurance. Nomination is there in mutual funds, your bank account, everywhere nominations are there. Now, what do these nominations actually mean? Nomination actually means that in case something happens to me, this nominee is going to act as a trustee who will hold any asset where he's a nominee in trust for my eventual legal heir. He is not the owner. So this is a real estate forum. I can very well openly speak over here that when if I have a flat and if I put a person as a nominee, this person, if I pass away, the nominee becomes the person who can handle the affairs of the flat. This is the person who will interact with the society, interact with, if there is a problem with the flat, then he will be the person who will be dealing with it till such time my flat is actually transferred to my legal heir. Because a lot of time people say कि हमने तो सोसाइटी में नॉमिनेशन लिखवा दिया, हमारे फैमिली मेंबर के पास चला जाएगा ये फ्लैट. The problem is it will go to your flat. Yes, he will become a member. But at the end of the day, registrar ke books mein, he is not the owner. So your title is not clear. He's the person holding it on behalf of your legal heir. And this stands the same in other forms where you are putting in nomination. The one place where nominee gets everything is in your demat account or in mutual fund. That's where the nominee gets everything in his name. Then we come to wills or wasihat. What is a will? Simple thing. I have got assets in my name. I want to transfer it to somebody or to some people after I'm not there. So I will make the will. So the parties to the will be the person who's making the will. If it's a male, then it's a testator. If it's a female, then it's a testatrix. The other parties are executors and beneficiaries. Now, why are these parties important? I, as a person, I hold the assets in my name. I want to transfer it to somebody after my lifetime. Then in that case, I will write down that I am in my sound health and mental health. I'm writing down this will where I'm going to put down what all assets I have. Then I'm going to say, who will be benefiting from these assets? It can be my child, it can be my spouse, it can be a charitable institution, it can be anything. And who will ensure that these assets get transferred to somebody? This person is known as the executor. In Bombay, the will has to be, it's not compulsory, but it has to be most of the time probated. Probated matlab ki hai? It has to be taken to the court. After I'm not there, the executor will take the will to the court and request the court that please make this will as the valid will, and that order of the court making the will valid is known as the probate. Probate comes into the picture only when I'm not there. Now there are multiple questions over here that do I have to register my will? No, you don't have to register your will. Do I need witnesses for my will? Yes, those are the people who make your will actually valid. These are two people who are going to be independent parties, which means they are not going to be the beneficiaries or you yourself. So the job of the witness is to see you signing. So they attest your signature. They are the most important parties in the will. Any amendment you make in the will can be done either by tearing off the earlier will and making a new will, or by making something called a codicil. Now, codicil is amendment to a will where you have to refer to the earlier will and then you make a new will. Same procedure has to be followed, that I am of sound mental and physical health, and I'm making this amendment. So probably the amendment can be that I had a house, I have sold it, now I have this new house, and this will go to so and so. While doing the codicil, you have to follow the same formalities, having two witnesses, you have to sign it. And when you have made the will, it need not be on a stamp paper. It is not necessary to have it printed in black and white. It is not necessary to have it on green paper. You can create a will on a simple white paper or in a notebook. You can write down the will, just make it properly and sign it and get two witnesses to sign it. That's it. The next slide is about a trust. Now the trust.
Neha, just sorry.
Sorry.
Yeah, sorry, Ashokji, you can if you want to.
Yeah. So Neha, can you tell us that does one require to have a video recording of the will, or is it mandatory to have a doctor's certificate attached to a will?
All right. So, sir, doctor's certificate, yes, advisable. And in today's time, very much advisable to have a doctor's certificate as annexed to your will, because this person is going to say that you are of sound mental health. Also, this, if possible, one should make this person, this doctor who's giving the certificate as a witness in the will. Then we come to the video recording. Video recording is now being admitted as evidence. It is a good way because nowadays we live in a flat and we are most of the time one or the other floor is sealed because of COVID. So we can actually get the people on the floor to say that please be my witness, and we will video record this entire event where I'm signing the will and you people are my witness and you are signing along with me. That particular video recording is admissible and should be done nowadays.
It's not mandatory, right? But it's
not
advisable
at all
to do it.
mandatory.
It's recommended.
It's a recommendation. It's not at all mandatory.
Wait, thank you.
Okay.
Ajay sir, you were saying something?
Oh, no. I mean, Ashokji asked you that question. I was about to.
Okay.
Sorry. Carry on.
Okay. Moving on to the next slide. We'll talk about the trusts. Now, the trusts that we are talking about over here are private family trusts and not the charitable trust. Though there can be public, private, charitable, different kind of trust. There are trusts that there are religious trusts. There are trusts that are running the hospitals. Then we have the private trust. The laws are different for these trusts. So public trusts or charitable trusts are governed under the Public Charities Act and Bombay Public Charitable Trust Act, which has to report to the Charities Commissioner, which has to register itself under Section 12AA of income tax. And we are talking over here about private family trusts. Now, these private family trusts are created under Indian Trust Act, which is as old as 1882. So it's a rather old act and has not been changed from that time till today. This trust, the different parties that are involved in creating a trust are the person who actually settles the trust, who's known as the settler or the creator or the author of the trust, who's actually writing down the trust deed, that I am writing down this trust deed as a document. He's along with some person. So if a husband is making, along with the husband, a wife can also settle the trust. So both of them can settle the trust jointly. That means they can form the trust jointly. Then the wife will be known as the co-settler. They will write the trust deed together, and they will be getting into a kind of contract with a person known as a trustee, who will be holding or handling the affairs of the trust, as well as maintaining the assets of the trust for the benefit of this another party called the beneficiary. Beneficiary is the person who will be benefiting from the trust. So if you see, it's quite similar to the will. Will is made by a person for a benefit of somebody else, and then there is an executor. Similarly, in the trust deed, there's a person who's forming it, there's a person who's benefiting from it, and there is a person who's taking care of administration, who's known as the trustee.
So,
now, sorry.
So, Neha, just a question. How many, what is the most commonly used trust? And, what are the different types of trust also, if you could enlighten us?
Absolutely, sir. So there are different types of trust, and they are different types based on the taxation. So income tax laws define that what are the different types of trust. So the first trust would be a revocable trust, which basically means that the person who has created it, so the settler or the co-settler who has created it, has got complete control of the affairs of the trust. These people, the settler can revoke or modify the trust deed. Revoke matlab shut down the trust completely, or modify the trust deed at any given point of time. Modification can be, he can remove the beneficiaries, he can remove the trustees, he can change the beneficial interest of the beneficiary. That is known as a revocable trust. The tax implication of a revocable trust is basically that trust income will get clubbed along with the settler's income. So it's like this, that if I have my child's income, so if my child is a minor, then in that case, if I have done any investments in my child's name, any income that will be derived on that investment will get clubbed along with my income. That is known as the clubbing provision. The same thing is going to be applicable in a revocable trust. The next type of trust is an irrevocable trust. Irrevocable is, as the name suggests, the person who has created it would not have any right to modify or to revoke or to do anything with the trust or the trust deed. The powers move on to the beneficiary or the trustee. He can contribute into the trust, but he can never take that money back. So it's like gift. So irrevocable gift. So money
Okay.
once given cannot be taken back.
Okay.
So that is known as an irrevocable trust. That gets split further into discretionary or non-discretionary, which basically means the discretion lies upon the trustee to decide how much which beneficiary is going to get, or non-discretionary is where who's going to get how much is very well defined upfront. The mostly people, if they are looking at protecting their assets against any kind of issues that may come in the future, then they would look at probably creating an irrevocable discretionary trust. Or if they want complete control in their lifetime, then they will make a revocable trust. So it will be dependent highly upon what a person's intention is.
Okay. Thank you.
So
Yeah, so Neha, before we move on,
yes,
can
sir.
you tell us, for the benefit of the 360 plus viewers, okay, what all can one hold in a trust? Can one also transfer property or company shares?
Okay. You can hold pretty much everything in the trust. What you hold can be held by a trust. You can transfer properties, you can transfer real estate, you can transfer shares, so any kind of investment that you're holding, that you can transfer into the trust. You can have a bank account linked to the trust, so you can transfer cash in the trust. You can hold jewelry through the trust. You can hold paintings through the trust. So we have clients who are holding paintings and jewelry through the trust because they want to ensure that their family jewels are protected.
Wonderful. Ajit, you have any question on this
Sure.
slide?
On the same lines, actually, that's why HNIs prefer, they want to do all these things through a trust, and she has answered it very well in a different way. But yeah, you can go
Okay.
on.
Yeah. So Neha, can you also tell us about the registration process of private trust, and are the compliances kind of similar to that of a company?
Okay. So the best thing about I will first go as per in reverse order. So compliance in a trust is absolutely against the compliance that are there in a company. So company has to follow the Companies Act, and then they have to report to the Ministry of Corporate Affairs. So and I think number of compliances are there when you are running a company. In a trust, that's the best thing. You can hold the assets and you can do investments. The only compliance that one has to deal with is filing income tax, timely income tax. That said, there is no other compliance. And the second thing that you asked about is the registration. Is the registration compulsory in a trust? No, if you are not holding any immovable property. So if you are holding an immovable property in a trust, or you are buying an immovable property in a trust, or transferring an immovable property in a trust, then in that case, the trust deed should be registered. So what happens is the trust gets its PAN-TAN and has got, because it has PAN-TAN, and if it does not have a property held by the trust, then it does not require a registration in the trust.
And what
Sorry,
about
then
stamp
it
duty
does
implication?
require, it's the same as an individual.
The stamp duty implication also is there when you register a trust and transfer property.
So when you form a trust, so to start with, when you start the trust, so you start it with a token amount of 10,000 rupees. There's something called settlement under Stamp Act, which basically has got a stamp duty of 3%. So you end up paying a 300 rupee stamp duty for the formation of the trust. After that, the trust can have assets transferred into it. So you transfer 1 crore of rupees into the trust and there will be no stamp duty implication. But if you transfer any real estate, there will be a 100% stamp duty implication over there because
Okay,
there
got
is
it.
a change of ownership.
Got it.
So taking a cue on this, how will then the assets of these trusts be used after the creator of the trust is no more?
Okay, the assets of the trust can, so that's when the trustee's job actually kicks in. So trustee's job is to ensure that either during the, not either, but during the lifetime of the settler and after the lifetime of the settler, the affairs of the trust continue to go on in the fashion that the settler has wished for and has written down. So the trust deed is like a Bible for the trust or a Gita for the trust, where one has to say whatever is written is like pathar ki lakir. So it has to go as per what is written down in the trust deed. And that is why the trust deed is an integral part of forming a trust.
Okay, thank you.
Shall I move on, sir?
Yeah, move.
So now the question comes that to the main question of this webinar, which is whether a trust or a will or trust versus a will. So the first 3 points we have seen, that who are the people who are forming the will or the trust, the testator or the testatrix. One thing one has to remember is, in a will, I can form my will. I cannot form my will along with my mother or my father or with my child. However, in a trust, I can form a trust along with my mother, father, child, anybody I want. So there can be multiple authors or creators of the trust. Second thing can be that, so the benefit is multiple authors, that means more people can transfer the assets into the trust. Second thing is, who are the beneficiaries? Beneficiaries in a will can be people who are actually present, people who are not present. So my grandchild, who's nowhere, means my child is not even married, so I can't think of a grandchild just now. So can I include that person as a beneficiary in my will? The answer is no. The beneficiary has to be people who are there present. So it cannot include future beneficiaries. Whereas in a trust, I can include my generation, my child's generation, my grandchild's generation who's nowhere there. And also one more thing I should tell you over there, I can exclude people in the trust. So I can say my child's spouse will be not a beneficiary of this trust. So I can have exclusions, very specific exclusions in the trust deed itself. Who can execute it? The executor. In a trust, it's a trustee. There can be multiple trustees. There can be corporate trustees as one wishes. Probate formalities in a will, it is mandatory. And usually nowadays, like when I talk to lawyers and we are talking about getting probate for our clients, they are saying, though we would say 6 to 9 months, you will get it, but nowadays we can't say anything. So it will lead to delay at this point of time. Trust, there is absolutely no requirement of probate. Why? Because in a will, actually a person is passing away and his assets are getting transferred to somebody else. So there has to be that transfer instrument, which is a will or a legacy or a probate, that has to come into play. A trust doesn't require any probate, because trust is made during the lifetime of the settler and can continue after the lifetime of the settler. It need not come to an end after the lifetime of the settler. So when we go in for probate, a will becomes a public document, thus there is no confidentiality. In a trust, you can have confidentiality as one of the main reasons, and people create trust because they want to have the confidentiality in place, not only from outsiders. At times they want some things not to be told to their own family also. Bankruptcy remoteness. Now, what is bankruptcy remoteness? This is a very interesting term, ring fencing or bankruptcy remoteness. It actually means that I have assets, I need loan against, I need loan. Bank is going to ask me for my assets, or again, they will ask me for my personal guarantee. If I'm unable to pay this loan and I pass away, the bank is going to come and they are going to invoke this personal guarantee. Then in that case, will is absolutely of no use because it can't protect against creditors. In a will also, the first right is not that of a legal heir, but that of a secured creditor. So you can't protect assets which you have already given given as mortgage or collateral to the bank. In a trust, this particular thing is possible. There are ways and means to ensure that the assets are transferred into the trust. There are ways to figure out that how the assets can be protected in the trust. There is nothing illegal about what I'm talking about. People are actually putting in their certain part of their assets away into the trust so that they cannot be attached by if they ever get into any kind of issues or problems. That is known as bankruptcy remoteness. So in a trust, that is a possibility. A control of assets post out lifetime is not possible in a will. So if I want to say that I want yearly donation to a charitable trust, every year I want a yearly donation, I can't write that down in the will. I have to write my X percentage or X amount will go to a charitable trust. I cannot continue that. If I do want to continue it, I have to create a trust to say that how I would want to distribute my assets in case I'm not there and have a continuous distribution. If I do not want my children to misuse the funds which I'm leaving behind, so that's called monitoring the funds, then in that case, I can't do it with a will. In case I'm not there, my assets through the will go to my kids. I can't control the end use of that. In a trust, I can say that, and that will be the trustee's job to ensure that the assets are monitored and used as per what my wishes were in the trust deed, that which were written down in the trust deed. In a will, you can make as many amendments as you need. So one day I have a fight, I have made my will, I have a fight with my family member, I can exclude that member. I can include somebody else. I can keep doing changes, because of which the contestability also increases in a will. So that you can make as many amendments, that makes it very easy. However, it also makes it very, one can go ahead and make a claim on the assets very easily also. In a trust, there is a structured progression, which means that whenever there is a change, that will be, if there are any changes, that will be about, if there are any changes in the asset base, it will be under the trust only. There is no change in the beneficiaries. If there are change in the beneficiaries, then in that case, all the concerned parties have to sign. Then in that case, the contestability also becomes a remote clause in a trust deed. So,
And yeah, so I think we've all understood. I mean, you've been really, really very explicit in your expressing your views. But can you tell us, I mean, if I was to ask you the layman, what is better, the will or the trust? I mean, if you can just enlighten our members, please.
sure, sir. So when I say that a will or what will be better, will or a trust, that's a very, it's a question as per individual's needs. So if a person says that I don't have so many assets, I don't have the objectives where I say that I want an end use or monitoring of my assets or any such thing, make a will. I want end-use monitoring. I do not want any kind of attachment on my assets. I want to create a corpus which will be protecting my family without my family being involved with the tax issues or any other issues. Then in that case, one should look at trust. Like a lot of people nowadays, a lot of families are looking at protection against, there's no right word to say it, but alimony. So if there is a bad marriage or a separation, then in that case, the family wealth should not be becoming a part of that separation process. So people are actually creating trust structures and transferring their assets in the trust so that the assets can be protected. Now, this is something very individual centric depending upon the objective, but either or both are a necessity. So one should not miss out on this.
Got it. Got it. Thank you so much. Yeah.
So we will go on to why estate planning is required. First thing, succession planning. So transferring the assets to the next generation. So with probate or no probate, by will or by a trust, you have to ensure that the assets go to my next generation. A lot of times I've met clients and they have said that मेरे तो 2 ही बच्चे हैं, उन दोनों के बीच में equal जाना है, so मेरे को तो will लिखने की भी जरूरत नहीं है. I'm a Hindu. Hindu Succession Act says that मेरे बाद मेरे wife और बच्चों का हिस्सा रहेगा. Now, this is where we avoid the personal laws. Now, these two things get clubbed because if I am a Hindu and my assets are going between my wife and 2 kids, actually what it means is that each and every asset of mine is going in 3 names. Probably I want to give everything equally, but not to all 3, all the assets. So I want to probably say that in case I'm not there, first of all, everything should go to my spouse so that my spouse is protected, secure. And then it should go between my children. Probably I want to give one property to one child and the second one to the second child. I always tell clients that please don't mix properties and give the same property to more than one child unless it is absolutely necessary to do that. There is no other way. Then give your property to all your kids together. But if it is possible, give them separately. If you want to do that, you need to create an estate plan.
Neha, sorry to interrupt you
Ji,
here.
sir.
Since you spoke about personal succession law, does a Christian or a Muslim need to probate a will?
So Christian and Muslims, Christians, yes, they have to do that. Muslims, this is a tricky situation where Muslims are allowed to create a will for 1/3 of their assets. So wasiat can be made only for 1/3 of their assets. The balance assets, they cannot give out as per wasiat. They have to go as per Quran.
Yes.
That is why we have so many clients who create trust. Lots of Muslim clients, they want to create trust because they don't want the personal succession laws to actually come into the, so like if there is a male earning member, he would not want that, everything goes as per Quran because it might not be as per his thought process. He may want his wife to be secured first.
Yes.
So then in that case, Wasihat or Quran is not the way forward, then you need to go through the trust route.
Okay, thank you.
Then we come to the most important part over here, which is the asset protection. So asset protection during a divorce or separation or any kind of creditor claim or a personal liability or a malpractice claim. So malpractice claim comes when you have a doctor in the family. So you don't want any claims to come to your family or to you, and because of which your assets are getting attached. So what people are doing is they are not, so here will is not going to be the best option. Here one would have to think about creating a trust, putting those certain assets away in the trust. Probably the member who is running the business or has given the personal guarantee should not be creating the trust and transferring his property. Somebody else in the family should be looking at creating this trust and transferring the assets. Another very important point where people want to provide for minors, special needs people, they want to provide for old age members. When we talk about minors, there is a requirement to provide for guardian. A lot of time people miss out on this part, that we are, again, we are a couple, we have got 2 kids, probably they are minor. In case something happens to me, mera spouse to hai hi, who will take care of my children? My parents are there, who will take care of my kids? My sister's there, who will take care of my kids? But we don't think about the fact that who actually would want to do that? You are entrusting this job on somebody, thinking this in your head. Put it down, take this person's permission that in case I'm not there, will you be able to do this for my child? Make enough provisions that in case something happens to you, your child or the special needs person or the old age person is taken care of. So a lot of time people are now making provisions. So provisions can be as simple as transferring the assets through the will in the minors or the special need or the old age person's name, and putting in a guardian or putting in people who will be taking care of them. For special needs person, this is not a possibility because they cannot hold assets in their name as per law. So people create trusts that can take care of them, that can take care of their special requirements, be it education, be it medical, be it any other kind of requirements that are there. A lot of time, and in continuation of this particular point only, one can maintain an investment pattern. So we don't expect people who are minors or special needs or old age people to do their investments by themselves. Then in that case, one can also put an investment pattern in the trust deed. This is a very important point where we are talking about estate duty or inheritance tax coming back in India, or inheritance tax management for people who have moved to different countries or are NRIs. So we have got clients who are either based in UK, US, or other jurisdictions where there are inheritance tax or estate duties. They can be as high as 44%. So in case I pass away, and I should say the estate duty limits vary, or they keep changing over there in those jurisdictions, and the laws keep changing over there. So though they are very dynamic, still one needs to manage their inheritance tax in India for the assets that they will be inheriting. A lot of times clients say that mera to ek hi ladka hai and he is in US or UK. Why would I want to transfer in case something happens to me? Sare assets uske paas chale jayenge and he will inherit. So what's the big deal in this? Why should I be bothered about inheritance tax? Now, this is the catch over here. If the assets are transferred to a person who is residing in another jurisdiction where estate duty is prevalent, then in that case, this person has to make a trust in India to manage the inheritance tax issue at some point of time or the other. Now, when he creates the trust and transfers the assets into the trust, and I will come to Mr. Mohanani's question, which he asked earlier, where he asked that is stamp duty applicable? This is where he is going to get into trouble, where he would have to pay a state income tax in his jurisdiction where he is, plus he would have to pay stamp duty to transfer those assets into the trust in India. So a lot of times people are progressive, they are thinking about situations like this, and they are creating trust structures where they are transferring the assets which their children will be inheriting into the trust beforehand, or saying that through my will, these assets, wherever there is stamp duty implication, people transfer those assets through the will into the trust. So the legacy has no inheritance tax in India or stamp duty in India. So they say that it gets transferred after our lifetime into the trust.
So that's the reason you say that HNIs prefer a trust than a will.
Absolutely, sir.
Okay.
Now, confidentiality, this is the point where people want to sometimes not tell even the family members that how much we are giving to whom. Then in that case, they would either want to write it in their will or they want to put it in the trust that who gets how much after me. Philanthropic goals, a charitable contribution after one's lifetime. This is a very important point because I've seen and off late being very prevalent where I have seen people want to do charity. People want to give assets to the people who actually need it rather than their own family members. So they want to give it towards causes. They want to give it to not an institution, but they want to give it towards causes. Then in that case, people are creating a trust to ensure that their charitable contributions are taken care of. Here, I'm going to take you through some case studies. There are only 2 case studies. I have kept it simple. So this is the unlisted company structure. Unlisted company structure, the family structure is that there is a mother, there is Mr. and Mrs. B. They have got 2 children together, daughter and son. Daughter is about to be married. Son has applied for US green card as, under the EB5 route. Now, the family assets are that they have a company, which is an unlisted company, which both husband and wife are holding. Investments in real estate, which they have. They have investments in listed companies. They have mutual funds, jewelry, cash at bank. Objectives are they want to provide for the family. They want to consolidate the assets because one daughter is going to be married and move to a different place. Son is going to be in US. They are all alone over here. They said that for the children's sake, we need to consolidate these assets. Second thing, the next thing is that they want to secure the family and the family's wealth from any kind of unforeseen risk. So thus ring fencing the assets and ensuring that the assets are going to the next generation without any litigation. So there is obviously an unequal distribution between the son and the daughter. So they don't want any problems in the future. So they are transferring assets in such a manner that there should not be any litigation. That they want a distribution in such a manner that only the income is distributed from the trust and not the corpus by itself. Again, they want a security against any kind of separation or disputes. And for the son, they said that we want to provide for her, for the daughter, they wanted that there should be a seed capital provision for any new venture if she wants to start. For the son, there is a planning that they needed to do for inheritance tax. Now, since both the family members are businessmen, they have created this particular structure. So they have created an irrevocable structure, so most commonly used structure, where when we talk about businessmen, where Mr. B, so the male member of the family, he has transferred his portion of the assets, not all the assets, portion of the assets into the trust. The beneficiaries of that, if you see, are not him, it's his wife and his mother. And after that, when wife and mother are not there, that's when the daughter will become the beneficiary. And after the daughter will be the future grandchildren. Similarly, his wife, Mrs. B, has created another family trust, which is a mirror trust, where the primary beneficiary is his Mr. B and his mother. And the next in line is the son and then the future grandchildren. The reason why they created an irrevocable structure because they were going ahead. If they had plans of expanding their company, they wanted to go ahead and take further loans. They wanted to secure or safeguard their existing asset base and ensuring that, in case anything happens in our family or in our business, our family is secured and safeguarded. So they have transferred only a portion of their assets. They have not transferred all their assets into the trust. Here, a will was formed by all the adult members of the family. So whatever assets they want to either transfer to each other through the will or through the trust was written down in the will. The next example is a little complicated, but I've kept it simple, which is for a listed company structure. Very simple family, sorry, which is family is Mr. and Mrs. A. Mr. A's parents are there. They have got 2 kids, both are minor, son and daughter. Mr. and Mrs. A are promoters of a company. They have got investment in equity market, real estate, jewelry, art. Their objective is very simple. They want an effective succession plan. They want to ensure that there's a provision for the current and the future generation. There should not be any claims against claims, disputes, or any claims for the alimony. They wanted to ensure that the family business, if we like today, the family is handling the business. They said that tomorrow, if we are not around and the children are not in a position to handle the business, they can professionalize. So they have already started professionalizing the business. They said that we want the professionals to eventually take over the business if our family doesn't want to be involved. Then in that case, we want our shares to be that pool of asset which is going to be giving our family income on a continuous basis. Promoters wanted their parents should be taken care of. Wife should be, so wife, actually she's a promoter, but she has never worked. So the male member wanted that wife should benefit all her, so wife, children, grandchildren, parents, everybody should be benefited for their income, medical, any kind of requirement, education, marriage, but none of them should be bothered for taxation. So we had created multiple structures for this family. Uh, 2 of them were similar to the earlier structure, and then these are the 2 which are created for his listed company structure. Now, what happens in a listed company structure, it's a particular thing. One has to go and take SEBI approval under, or a SEBI exemption order under the takeover regulations, where you are transferring the uh, listed company shares, so that there is no open offer that gets triggered. One would have to go ahead and take a SEBI exemption order. So nowadays it has become easy because SEBI has come out with the regulations. Earlier it used to be very difficult when actually we have done quite a few deals at that time when it used to be a very tedious process to transfer the shares into the trust. So again, this is a structure that has been created similar to earlier structure. Mr. A has created one trust where the beneficiary is Mr. and Mrs. A. Mrs. A and his mother. And the other one has been created by Mrs. A, where the beneficiary is Mr. A and the mother. Uh, in the first trust, the son and the future grandchildren are involved. And the second trust, the daughter and future grandchildren are involved. The reason why they have done 2 separate trusts is because they don't know where their kids are going to be after some time. They are minor at the moment. When they do get older, if they go outside to study, would they want to stay in that jurisdiction? That was one point. Second point was, so they wanted that the assets are segregated before time and the children can benefit from them. And then the last thing which happened was, again, there were assets that were left outside the purview of the trust. These assets were covered under the will which was made by all the adult members of the family. So with this, I would summarize the presentation, that please do not delay this process. And as earlier said, that whether it's a trust or a will, make one of them at least, if not both. So,
Okay, that
yes.
was that was great, Neha. Just one more question.
Yes.
If you can let us know, what is a living will?
Sorry, sir, I can't hear you.
What is a living will?
Okay, sir. So a living will is basically a will that has been made for passive euthanasia. It is a will that it's quite close to the will that we create, but it
Okay.
gives a person, so like if I create it, I will give somebody the authority to deal with my treatment or to withdraw my life support in case I have turned into a vegetable and not responding well. So I give that authority to somebody. However, in India, the living will by itself, it has become so difficult to make because one has to register it, get to register it, not at a sub-registrar, but with the judicial magistrate first class. After that, he is going to ensure that it is not out of force and coercion that you are writing this will, and then he is going to put it, preserve it at the registry of the district court. And this is only the procedure of making the will. If you want to make any amendment in the will, or you want to make any changes in the will, it is, or if you want to actually invoke, if this person wants to withdraw the life support, that itself is a procedure by itself.
Oh, thank you.
And yeah, now there's one question which is being asked by one of the colleagues on the dais, is that what is the difference between a private and a charitable trust? If you can tell us that.
Right, sir. Very simple. The first thing is private trust is, both the laws are very different. A private trust is formed under Indian Trust Act 1882. A charitable trust is formed under the, like in Maharashtra, if we talk, it is formed under Bombay Public Charitable Trust Act. There are no tax exemptions that are there for a private trust. So it is as if an individual is getting taxed, the trust is getting taxed. No special exemptions are there. Like how you have in charitable trust, if I contribute money, I get exemption. So I get tax benefit for that. That is not a possibility in a private trust. A private trust is handled, it's more like for public at large. It has to, the objectives are to help public. In a private trust, it is for the benefit of my family. So if I am creating it, it has to be for the benefit of my family. And when I create it for the benefit of my family, and strictly speaking, as per income tax and the definition of relatives, then only this trust becomes tax free for me, where I am transferring, if I am transferring any funds to the trust, it will be considered as a gift and I don't have to pay tax, or the trust would not have to pay tax on the receipt of the gift.
Got it. So I mean, can I request Nikhil from your team to collate the questions and and put it, and the audience has a lot of questions, and so he can coordinate and ask you the questions. Nikhil,
Sure.
please.
Yeah, sure, sir. Am I audible?
Nikhil, one second.
Yes.
Dr. Hiranandani has a question.
Yeah,
Okay.
Neha, what is the tax differences between a discretionary trust created and a regular trust, private trust, which is specific in its terms of beneficiaries?
All right, sir. So I'm guessing both of them are irrevocable.
Yes.
Yes. So specific is determinate trust, where the beneficiaries are determined and their beneficial interests are determined. And discretionary is where only the beneficiaries are determined and their beneficial interests are not determined. So if you say, I have got beneficiaries A, B, C, and what are they going to receive and when are they going to receive is not mentioned, then in that case, it's a discretionary trust, which means that you are giving discretion, you as a settler are giving discretion to the trustee to decide that how much he is going to distribute and when is he going to distribute to the beneficiary. So the income tax, what happens is, in a logical way, that if we see, the income is generated at the trust and one does not know whether the beneficiary is going to receive it or not receive it. So income gets taxed at the trust level at maximum marginal rate. However, capital gain, short-term, long-term is different. Then comes the determinate or the specific trust, where when you as a settler have created the trust, the beneficiaries are known. So A, B, C are known. Their beneficial interests are known. So you have said that they are going to get 30, 40, and 30. So their interests are known. Then in that case, whatever income is generated at the trust level, whether distributed or not, can get taxed either at the trust level or at the beneficiaries level. So if beneficiaries think that it is better for us that we take the money in our hand and we get it clubbed, we tax it at our level, then it will be at their level. So either or one place, it will get taxed.
Thank you, Neha.
You're welcome, sir.
Yeah. Yeah, Neha, I'm audible.
Yes.
Yeah, I'll try and club questions as much as possible because there are a lot of questions.
Yes.
So first question is I'll club that. What is the difference between a will and a registered family arrangement, and what is the stamp duty implications for a asset transfer through family arrangement?
Okay. So family arrangement is something that one does during their life to transfer the assets to each other. So like if there is a family of 10 members and they all have got disputes, or they are not talking to each other, or there is a probability of dispute coming in because of the property that is held in multiple names or in single name, which has to be distributed amongst multiple people, then in that case, a family arrangement will be written down, or a family settlement deed will be written down between these members. The thing about stamp duty is if there is a title that gets changed, then there will be a stamp duty implication. However, if there is just an understanding, if it's just written down and not causing any kind of title problems, then in that case it need not be registered. There will not be any kind of stamp duty. You can take it on a 100 rupee stamp paper and that's about it. I'm sorry, what was the next part of the question? One was arrangement and the other one?
No, you answered that. It was
Okay.
regarding the stamp duty and the difference between a will and a family arrangement. You answered that. The second question is, you have covered this part, but just to reiterate, is a gift irrevocable and can a gift deed be cancelled?
No, irrevocable gift होता है. एक बार दे दिया आप वापस नहीं ले सकते. Yes, there are some new provisions that have come where if parents have given it to a son or a daughter, then in that case there is a and they are supposed to maintain the parents, and they are not maintaining the parents, then in that case they will the gift can be revoked.
Okay. What if there are any corrections in the will? Is it acceptable? What I understand from this question is there are two things. One, if there is corrections, when they have to make some changes to the will, or if there is some kind of a spelling mistake or something in a will, probably both I think you can answer.
Okay, if there are corrections that have to be made, so if the corrections are just like putting an I or putting an E, if you have missed out on a letter, just scribble that EI over there and initial or sign over there. However, if there is more than just a spelling mistake, take out another printout, sign it, and get witnesses to sign it.
Okay, thank you. This question is regarding the settler of a trust. What if a settler and both the settlers pass away? In their absence, can the trustees dissolve the trust?
It will be highly dependent upon what is written down in the trust deed. So if it is written down, the trustees have the power to do that. They, along with the beneficiaries, can do that. Generally, the provision states that the beneficiary would have to agree to what the trustee does. If it is not written, then trustee might be able to do that. But that is a question, very generic question. So one has to go through the terms and conditions to answer that.
Correct. One more very specific question from one of the participants. He says that my father passed away without writing a will. We have a large inheritance. Is the inheritance automatic without a will?
Depends. If it's a large inheritance, what I understand is banks don't transfer anything beyond 2 lakhs without probate or a legal heir certificate. So you have to get a legal heir or certificate or a letters of administration. It has to be distributed as per the law, your personal succession law. So you would have to file a petition in the court for that.
Correct.
To get a clear title.
Correct. Correct. I think this also you have covered, but just to for the benefit of the larger audience, when we create, how would it benefit? When we create a trust for a minor or a specific special child like an autism child, how it will benefit if we create a trust for them.
So it is beneficial to create a trust for them because one, you can have roles and responsibilities of different people defined in the trust deed. So you can say that what is the job of a caretaker, who can appoint a caretaker. So you can you can write down people who can appoint caretaker, who's the doctor who's treating him, what are the, in case he is not like, I can give you a live example here. We have a client who has got a child who is, in case something happens to husband, wife, there is no place the child can stay. So they are actually, they have taken a special needs home for him where the child will be taken care of. So he goes once in 6 months or 4 months, stays over there. The payment of that can be written down in the trust deed. Who can, then people who will be doing the investments for the trust, that can be written down in the trust deed. When and how the money will be distributed if the child is not there. So that is also a thought that one has to think about. That is also written down in the trust deed. So all the tough decisions that as a parent you are taking today, that will be written down in the trust deed. So basically you are making your charter to take care of your child.
And at the same time, I think envisaging the right people as the beneficiaries.
Exactly, exactly.
Right. One more question, Neha, on slightly similar lines, but he says that, I wish to write a will, where I want to give my shop to my child A. But for some reason, in future, if my child starts a business like a butchery, gambling, or liquor shop, then the ownership should not go to child A, but it should go to child B. Is this possible in a will, or it should be done through a trust or a company?
It should be done through a trust. It can, so you can write these kind of things in a will. Nothing stops you from writing. But what happens is that what if the child does all these things after you are not there? Then you can't stop this, or you can't transfer the title after that. So a trust is a better option than a will, or rather you transfer, you say in your will that the asset goes into the trust, and in the trust you write down these provisions that if this premises cannot be used for ABC purposes.
Right, right. Another question is, can we transfer assets which is mortgaged to a trust?
आज से 15 साल पहले तक, yes, you could have, but at the moment it's highly impossible because more than anything, the lenders are asking nowadays for trusts also to give guarantees. So if you do transfer, you are jeopardizing all the other assets also.
Okay. Can you transfer agricultural property to a trust?
It's a gray area. There are people who have done it. There are people who are not able to do it.
This is regarding the succession of the trustee. How do you appoint a trustee, post the lifetime of the settlor or even the current, trustee?
So trustee is a person who's an administrator. So if the settlor is not there anymore, he can appoint parties in the trust. He can give the option to the beneficiaries to have the right to change the trustee. He can give the trustees the right to appoint the future trustees. So again, this is a very large answer question. So you can, there are multiple options available for that. So you can always write down about who can the successor trustee be in the trust deed, or give the power to the beneficiary, or introduce another party like a protector who can decide on how the beneficiaries, how the trustees will be changed and when they will be changed.
Right. If a NRI makes a will to transfer the property to a trust after his demise, in that case, the trust will be the ownership of the property and the society will be transfer the share certificate in which name? I mean to say they're asking whether it will be in the name of the trust.
Yes, it will be in the name of the trust. Society will would have to do the transfer, but he would have to make that will. That will has to get a probate because society will not recognize a trust till such time they have a legal binding to recognize a trust.
Right. Regarding the will part, can the beneficiary be also the executor of the will? And we can also add the witness part as well in this, because that is also a question.
Can a beneficiary be an executor to the will? Yes. And what's the next question?
Can the beneficiary be also the witness?
No, beneficiary can never be the witness. A person who's benefiting can never be a witness to the will.
Okay. On the similar lines, can a beneficiary in what scenario or what type of trust a beneficiary can also become the trustee of a trust?
In what scenario where if it is written down that the beneficiary should become a trustee to the trust, one. Two is, though it is, it is possible, nothing in law stops it from a beneficiary being a trustee. One should think about various aspects such as would there be any conflict of interest? So if the son is a beneficiary to start with, along with the daughter, and if he becomes the trustee, will there be a conflict of interest? If he becomes a trustee, he will probably transfer the benefits only to himself or his family and not transfer anything to the daughter. Would that be right? So there are considerations to be thought about.
I think I'll take just last couple of question. I think, yes, I think we have already overshot the time. I think this question is against law against perpetuity. So what is the expiry period of a trust?
99 years is the expiry of the trust under the law against perpetuity. But one would have to know that we can create trust for 2 present generation and 1 future generation. So it will be dependent upon their age also. And in that also, you can say that the next generation has the right to increase the term of the trust. So the next generation again will have himself, the next generation, and a future generation. So this can go into perpetuity also.
Okay. I think rest all questions, I believe it's on the similar lines, which you have answered already.
Okay.
So, yeah.
All right. So I will hand over the baton to Mr. Ajay Kapoor.
Yes, hi, am I audible?
Yes.
Great. So that was an amazing session, Neha, really amazing. Thank you so much for taking us through this complex subject with such amazing clarity and detail. You've given us an excellent grip on wills, trust structure, the similarities and the differences between both. Many of us actually on this forum interact and engage with a lot of HNIs, ultra HNIs, large business families, CEOs, MDs of large companies. We are now actually truly empowered to engage with them on areas related to the estate and wealth management, which will surely help us strengthen our relationships with such clients and associates. So thanks a lot to you. On behalf of Trek and NAREDCO, I'd like to give a word of thanks to all the key people who have been involved with this knowledge series and helped make this session a great success. Firstly, our chief guest, Dr. Niranjan Hiranandani, President NAREDCO and Managing Director for Hiranandani Communities. Thank you, sir. Thank you so much for being with us for this important and relevant topic of discussion and emphasizing the importance of this topic in the beginning of a session. Thank you for your time, sir. Secondly, our guest of honor, Mr. Rajan Badilkar, Vice President for NAREDCO Maharashtra. Thank you, sir. Thank you for all your time, for all your valuable inputs for a discussion today. Thank you for updating us with the updates from NAREDCO side at the beginning of our webinar. Thank you, sir. Neha Patak, Head for Estate Planning and Motilal Oswal Private Wealth Management. Thank you, Neha. You've been our speaker and our star of today's webinar. Thank you so much for sharing your an amazing width and depth of information, much needed in today's times. Thank you for putting it all together so well for us. We really appreciate all your knowledge and inputs which you've shared with us today. Thank you so much. Mr. Ashok Monani ji, President NAREDCO Maharashtra and Chairman for Ekta World. Ashok ji, thank you so much for all your time, multiple inputs and ideas in the last few days to ensure that we make this topic known to all our audiences. Thank you for moderating this so well today in your true signature style. Superb. Mr. Ajit Rao, Member Trek and President Smart. Ajit Bhai, thank you so much. Thank you for being with us. Thank you for helping us moderate this important subject and discussion,
My
and
pleasure.
helping us with the organization of today's session. Thank you very much.
Thank you.
Lastly, thank you to all the team members of NAREDCO, all the members from Motilal Oswal Private Wealth Management team. Thank you to all our association partners, Smart, Area, Thane Estate Agent Association, Kandivali Estate Agent Association. Thank you for partnering with us, and thank you for working so well together with all of us. Lastly, thank you to all my colleagues from TREC, our chairman, Mr. Avinash Khattar, Mr. Ashok Narang, who has been the key backbone and for initiating as well as organizing this webinar, and to my colleague Sanjeet Narayan for all your inputs, value additions during the organization of the webinar. And of course, thank you to all our participants and our audience for taking time out and joining us for this knowledge series webinar. Thank you, everyone.
Thank you, Ajay.
Thank you.
Okay.
Ajay.
Thank you.
Neha.
Great event. Thank you, everybody.
Thank you.
Thank you.
Bye-bye.
Bye.
Thank you, everyone.
Good day.
Thank you.